Good, how are you? Nice to meet you too. Felt like Good morning, everyone. Can you hear me okay? All right. Thank you for joining us today. My name is Brian Sharon. I'm the principal here at Powers Catholic High School. I'm honored to share this experience with you. For those unfamiliar with our school community, Powers is a co-ed Catholic school that was founded over 50 years ago when 7 local Catholic schools merged. We spent 40 years in our original location on Carpenter Road before moving to this facility 10 years ago. With the generosity of our stakeholders and community leaders, the move was made possible. Our academic building is over 100 years old and was in use by various organizations over the years, including our neighbors at Michigan School for the Deaf. Powers Catholic serves over 550 9th through 12th graders who come to us from 56 different middle schools from over a 35-mile radius. Powers Catholic is one of 4 high schools within the Lansing Diocese. Our other partner diocesan schools include Ann Arbor Gabriel Richard, Jackson Lemon Christi, and Lansing Catholic. Today marks a tremendous learning opportunity for us all. As educators, we encourage students to be active participants in society, to think, to engage, to strive for justice, and to create opportunities to build leadership and think critically. Today, the Michigan Supreme Court is bringing us a unique and authentic learning opportunity experience to see people at the top of their professions facing issues related to constitutional law on a stage that will soon host The Lion, the Witch, and the Wardrobe. In preparation for this event, I had the wonderful opportunities to work alongside Raven Gilmore from the Supreme Court and the Supreme Court security team. Thank you for your time, your hard work, and willingness to trust our school with the honor of being your host. I'm beyond grateful to the court for bringing your work to our community. The gift of education, their time, their experience is the greatest gift they could ever give. We are incredibly honored, humbled, and gracious to host the 28th Community Connections program. Thank you all for being here, and welcome to Powers Catholic. God bless you all. I would like to welcome one of our juniors, Regan Littleton. She is the president of the Powers Catholic Law Club and one of our student house captains. Regan will lead us in the Pledge of Allegiance, so please rise.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Now I'd like to extend a warm welcome and introduce Chief Judge David Newblatt of the 7th Circuit Court in Genesee County.
Good morning. I'm David Newblatt. I'm the Chief Judge of Genesee County Circuit Court and Probate Court. And at this time, we're going to have the judges proceed into the auditorium to take their seats so they can begin now, and then I'll introduce them as they are walking to their places. Judge Colleen O'Brien, Michigan Court of Appeals. The following judges are circuit judges from 7th Circuit. Judge Celeste Bell, Judge Chris Christensen, Judge John Godola, Judge Elizabeth Kelly, Judge Mark Lachana, Judge Elizabeth, she's a judge twice apparently. Judge Sardano, Judge John Weir, and Judge Ariana Heath. The following judges are 67 District Court and the Chief Judge Christopher Odette, Judge William Crawford, Judge Jennifer Manley, Judge David Gwynn, Judge Mark McCabe, Judge Jessica Hammond, Judge David Goggins, Judge Tabitha Marsh, Judge Herman Marable Jr., and we have a visiting judge in Genesee County. That would be Judge Richard Ball. We also have the following retired judges with us today: Judge Joseph Farah, Judge Duncan Beagle, and Judge Nathaniel Perry. Thank you. You may be seated. This time, it's my pleasure to introduce to you Marcus Garvin. Marcus is a combat veteran of the war in Iraq. In that war, Marcus suffered grave injuries from a car bomb, which caused him to lose a lung. He required 60 surgeries, but he is also something else. He is a shining star example of success in Judge Barkey's Veterans Treatment Court program, and he has become a mentor to many. I would like to have Sergeant Garvin say a few words about the impact that the program has had on him.
Hello, my name is Marcus Garvin. Coming here today and speaking on behalf of not only all the veterans of the state of Michigan, but specifically those who have found varying degrees of success in the Genesee County Veterans Court is one of the highest honors I've ever had in my 42 years. I remember my first true awakening in life, that the world was so much bigger than I realized. During the initial stages of the invasion in Iraq, I remember watching the news while unlacing my stained and dingy shoes after a long day at a minimum wage job. And I was struck by an incredibly powerful idea that would change the course of my life forever. The idea that somewhere in this nation was a man getting ready to lace up a pair of combat boots. And that man was a soldier who would one day give his life for a country that I had done nothing but take away from. The next day my journey began. I raised my hand and I took my oath, and I drove home that evening comforted by the fact that I was finally being given the chance to pay the tab that my adolescence had ran up against my citizenship in this nation. Since that day, I have graduated from infantry training school, airborne school, and ranger school. I deployed 3 separate times to Iraq, to Fallujah, Ramadi, and Habaniyah, in conjunction with both the Army and the Marine Corps. And while I can reminisce about that time, I cannot really remember a moment where I knew who I was, and I was not that version of myself. Then in the blink of an eye, and the tick of a detonator, my world went black and I woke up in Germany. Having lost the function of my left lung and much of my lower intestines to a car bomb, I was subsequently stitched up, rehabbed, handshaken, congratulated, and sent home without ever finding out who I was supposed to be, now that that version of myself was gone. Never for one moment in all these years did I stop and consider what I was going to do if I could not die for this nation. If I could not give my life, what else of value did I have to give to my flag? So I came home and I hung everything up in my closet, and that was it. I took no further steps, and I forgot everything I had learned about who I was. And it was a month before I looked at myself in the mirror again, and by that time, I did not even realize who it was I was looking at. I went to every single appointment that the VA made for me to fix my physical wounds. The number of surgeries I've had to put my body back together is more than 70. I've lost count. While I endured them as I needed to, I did so because it was easy. Easier, in fact, than the effort that would come later, as more and more I became aware that I was losing myself to a fog of indifference and a continuing and increasing inability to take care of the man that was trapped inside the mind of the body that I had broken. The edges of my individual and distinctive silhouette began to blur, and with the loss of mission came the loss of self. And then I found Genesee County Veterans Treatment Court. And as I stood there alone, watching, filled and overcome with anger, pain, resentment, and regret, I found a new mission. As I stood in that courtroom, watching as every individual's hearings played out, I realized without even recognizing it that I had found myself once again surrounded by a camaraderie and brotherhood that I thought was gone forever. To my left and right were soldiers, airmen, sailors, and Marines with their own individual wars raging internally. And I instinctively knew that the fact that we were all fighting these battles alone was proof that none of us would actually ever be alone again. And in that moment, my resentment and guilt, not only being not allowed to die for my nation, melted away. And it was replaced by a newfound commitment to instead live for it. In the time since I have returned home, since rediscovering my authenticity and strength as a man, as a resident of Genesee County and a United States Army veteran, I have completed 4 separate undergraduate and graduate degrees. I am a single father. I have worked for the local schools as a social worker and the state with Child Protective Services. I was the president of the PTO at my daughter's elementary school. I fight tirelessly and endlessly for the recognition of fathers' rights. And as we speak, I am excused this morning from the Mott Police Academy, where I will soon join the ranks of those officers who protect and defend the city of Flint with their very lives. Yet nothing I have encountered on this road to self-discovery has been as important to me as the work I did standing tall inside of our courthouse every single week and representing the men and women of Genesee County Veterans Treatment Court. This court has enjoyed its successes and graduated men that have otherwise lost all hope, and we have mourned our failures and buried men that we called our brother as well. Yet, win or lose, we have consistently done so together. Veterans Treatment Court provide a unique and compassionate approach to justice, recognizing that the experiences endured by our military personnel leave so many scars that are invisible to the naked eye. Diverting veterans away from the traditional court systems, we offer these heroes a chance to rebuild their lives by prioritizing rehabilitation over punishment. It has never been more important to recognize and address the root causes of veteran struggles such as mental health, substance abuse, and combat-related traumas. The collaborative effort between judges, mentors, counselors, and community organizations demand that we prioritize continuing to fund these diversionary courts, not only as an imperative, but part of the debt that we owe as Americans to its warriors that have sacrificed so much in returning to civilian life. The cost of tailored treatment programs, increasing access to counseling and mentorship from fellow veterans, and providing a path towards recovery and a brighter future is insignificant when weighed against our moral obligations as a grateful nation to ensure that those individuals who have fought for our freedom receive the support they deserve. We must continue to champion the cause of veterans treatment courts at every opportunity and always advocate for their expansion and continued integration to allow veterans who have lost their way to reclaim their lives and discover what new heights await them by requesting that both the legislature and the judiciary satisfy the debt incurred by the public to these men and women through continued financial support of veterans treatment courts across the state. Thank you.
Sergeant Garvins, thank you for your service. Thank you for being such a shining example and an inspiration. Hello. The justices will be out taking their places soon, and it's my privilege to offer a few introductory remarks about what you're going to observe. I'd like to pose a question. What is the law? On one hand, that's an easy question. It's what I do every morning after I brush my teeth and drive to work, to my job as a trial judge. But on the other hand, it can be a hard question to pin down. Why is that? Well, for one thing, the law keeps changing. Take any area of the law and you can see it. You don't have to be a lawyer. All you have to do is read the news, and you can see enormous change in the law with regard to guns, abortion, marijuana, and on and on. So the law isn't so much a thing as it is a process. But if there is a big idea, it's that the law is here to resolve conflicts. If you and your neighbor are fighting over where the fence goes, you can either have a shootout at the OK Corral, or you can file a lawsuit. But how does a judge decide where the fence goes? Our system of government was set up by the United States Constitution to determine how the law would be made. You see, the Constitution, in a way, wants to have its cake and eat it too. Why is that? Because it features two contradictory ideas. On one hand, you want effective power. But on the other hand, you want limited power. How can you have both? This is the genius of the Constitution, and this is how the Constitution solved it. The effective power would be vested in a president and a Congress, while the limitation of that power would be tasked to the judiciary, judges. It was none other than Alexander Hamilton who wrote about judges in the Federalist Papers. Yes, that Alexander Hamilton, the star of the Broadway show. He certainly didn't throw away his shot when he described the judiciary as the weakest of the three branches of government. He noted that the president held the sword and Congress held the purse. But what did judges hold? Well, here's the answer. Absolutely nothing. Judges hold nothing. And you know that gavel they give us, that doesn't count because they won't let us throw it at the lawyers. So the only thing that judges have is their good judgment. Think of it. Our entire system of government depends on that, on judges making good decisions. And that's a lot of pressure for us judges. And that's why we have to write opinions about how we come to our decisions. Like in 8th grade algebra, we have to show our work. This is for the benefit of the parties. It's a lot easier for the losing side to accept the decision when they understand why they lost. But we also have to show our work so that our decisions can be appealed. My brother's an emergency room doctor. If he makes a mistake, there's no appeal. But if I make a mistake, appellate judges can fix it. And I'm grateful that they do. But sometimes appeals courts don't reverse us because we made mistakes. Sometimes they do it because they want to change the law. So a case can serve two purposes. One, to resolve a conflict between litigants, and the other, to change the law for all cases. We've all heard about Brown versus Board of Education. This was a case that started at the trial level when Oliver Brown thought it unjust that his daughter Linda should have to ride a bus to a faraway segregated school when she could just walk a few blocks to the closest school. It would end with the landmark Supreme Court ruling that racial segregation violates our Constitution. And so, this decision changed not only the life of Linda Brown, but it changed the course of history for our entire country. So as you watch today's hearing, remember that this case started in front of a trial judge like me, just like Linda Brown's did. As for the question I posed at the beginning, what is the law? The answer you'll get to see. It will be determined through the good judgment of our Michigan Supreme Court. Now I'd like to welcome Michigan Supreme Court Commissioner Daniel Brubaker and Commissioner Liza Moore.
Hi, good morning, everyone. So at one of our prior programs, when it came time for the questions after the oral argument, the first student who raised his hand got the mic and said, I have kind of like no idea of what I just saw happen here. And I appreciated that kid's honesty, but I thought that's kind of a failing on our part. So if you're sitting out there wondering like why you're here and what it is you're about to see, we are going to try and help. First, this is an oral argument before the Michigan Supreme Court. The Michigan Supreme Court is the highest court in Michigan. Okay, I'm doing something wrong, or? We have a great PowerPoint. Ah, there we go. Okay. Here we go. There are 7 justices on the court. These are the current justices who sit on the Supreme Court now. I must not be in range. The Chief Justice is elected by her fellow justices. Our current Chief Justice is Justice Elizabeth Clement. Justice Zara is the longest serving of the justices at this point. Justice Viviano is next in seniority. He's from Macomb County. Next is Justice Bernstein, and although Justice Bernstein is blind, he and I recently ran a 5K together, and yes, he beat me. Justice Kavanaugh is next. I had the pleasure of, or the honor of working with her father, Michael Kavanaugh, when he was a justice. Whoops. And then Justice Welch, who's fairly new. She began her term in 2021. She's the only justice from Grand Rapids, which is my hometown. And then our newest justice, is Justice Bolden. She was appointed by Governor Whitmer and began her term just this year. I happened to be at her swearing-in ceremony at the Capitol in November, which was a very important day in Michigan history. So the justices have 8-year terms unless they are appointed to fill another justice's term. And the way that it works is there's a lot of district and circuit courts in Michigan, and that's kind of where your case starts out. But if you don't like the result that you got in your district or circuit court and you're going to appeal, then you go to the Michigan Court of Appeals. And there's several offices of the Michigan Court of Appeals around the state, but there's just one Supreme Court, which usually hears cases at the Hall of Justice, which is right down here at the bottom right. That's our office, so that's where the court usually hears the cases. That's in Lansing. So unlike the lower courts, the Supreme Court doesn't have to take cases. There we go. The parties have to ask the court if it'll please take the case. So we get about 1,400 to 1,600 applications every year, and we only hear arguments in about 80 of those cases. The court is generally going to be most interested in the cases that are going to have a significant impact on the lives of the people of the state of Michigan. So, and this is oral argument. So unlike a trial court, there's no juries when you're at an appellate court like this. Instead, each party is attempting to persuade the court that the result from the Court of Appeals was either correct or incorrect. So they're arguing about whether the lower courts got it right. There's no objections on either side. It's not like a television courtroom drama where somebody's going to stand up and yell, "I object." There's no witnesses, and the attorneys don't interrupt each other, although the justices can ask questions, and they frequently do. I will now turn it over to Commissioner Moore, who will talk a little bit about the case.
Thank you, Dan. Good morning, everyone. Today we are so honored to be able to see the work of the Michigan Supreme Court in action. I'm here to talk a little bit about the case that the court is going to be hearing, so that especially the students can have a little bit of understanding about what the court is going to be hearing today. Today, the court is going to hear the case of Long Lake Township versus Todd and Heather Maxson, and this case involves drones. As some case background, Long Lake Township is up north. It's up by Traverse City, and this case pertains to 5 acres of land that's owned and lived on by Todd and Heather Maxson. Back in 2008, the township instituted what's called a zoning enforcement action against the Maxsons, alleging that their property was being used in violation of the zoning ordinance. In 2008, that lawsuit settled, and the township agreed to take no further action regarding the land, regarding any facts and circumstances they had discovered in that litigation. Subsequent to that litigation concluding, it's alleged that a neighbor reported there was additional material being stored on the property. The township decided to retain a drone company, and that drone company took aerial photographs of the property at issue in multiple years. Then the township brought the action that we're hearing today, another zoning enforcement action alleging that there had been a violation of the zoning ordinance and that the use of the property was expanding. They attached the photographs that that drone had taken to their complaint. The Maxons moved to suppress those photographs, saying that they had been taken in violation of their Fourth Amendment rights. So that brings us to the issues that the court's going to be considering today. One, whether or not the township violated the Maxons' Fourth Amendment rights by using an unmanned drone to take photographs of their property for use in a zoning and nuisance action. And two, whether the exclusionary rule would work in this case. So let's unpack those two issues a little bit and talk about the legal principles underlying them. Now, I'm going to assume that even the students, that you all know about the Fourth Amendment. It's one of the most important provisions of our American Constitution. The Fourth Amendment protects people from unreasonable searches and seizures. The exclusionary rule is what happens after there's been a violation of the Fourth Amendment. The use of evidence that has been obtained in violation of the Fourth Amendment is prohibited by what's called the exclusionary rule. It's a judicially created remedy that's mainly aimed at preventing future problems, future violations of the Fourth Amendment. There have been cases that have limited its application. For example, there have been prior decisions that have held that it does not apply in a probation revocation hearing or in a civil tax proceeding. With those principles in mind, let's turn back to the case that you're going to be hearing more about today. As I mentioned a few moments earlier, the township filed a zoning and nuisance action alleging that the property was being used in violation of the zoning ordinance, and they attached photographs, including photographs that had been taken by the drone. The Maxons moved to suppress those photographs, arguing that they had been used in violation of the Fourth Amendment. The trial court heard that motion after hearing oral arguments and decided to deny it, reasoning that the Fourth Amendment didn't apply, there was no reasonable expectation of privacy. The Maxons filed what's called an application for leave to appeal to the Court of Appeals, challenging that decision to deny their suppression motion. In 2021, the Court of Appeals decided that after granting leave. The Court of Appeals had granted leave on the limited issue of whether or not there had been a Fourth Amendment violation here. And in a published decision, the Court of Appeals decided that yes, the trial court decision should be reversed. The trial court had made a mistake, according to the Court of Appeals. The Court of Appeals said that the drone surveillance at issue implicated the Fourth Amendment, and as such, there was a reasonable expectation of privacy, and without a warrant, that there was a violation of the Fourth Amendment. One Court of Appeals judge dissented. After that, the township filed what's called an application for leave to appeal to the Supreme Court. After obtaining some additional briefing, the Supreme Court decided to vacate that first Court of Appeals decision and send it back to the Court of Appeals for consideration of an additional issue of whether or not the exclusionary rule would apply in this case. On remand, the Court of Appeals issued a second published opinion. And in this case, they decided that the exclusionary rule did not apply here. The Court of Appeals said that even if the township violated the Maxons' Fourth Amendment rights, the exclusionary rule would not operate to bar the photographs at issue. And this time, they affirmed the trial court ruling. Now we're getting to what you're going to hear today. From that decision, the Maxons filed an application for leave to appeal to this court, the Supreme Court, and this time, the Supreme Court decided to schedule oral argument on the application. That's the oral argument you're going to be hearing in just a few minutes. The Supreme Court directed the parties to submit additional briefing regarding those issues I mentioned earlier, whether or not the township violated the Maxons' Fourth Amendment rights by using an unmanned drone to take aerial photographs of the property for use in a zoning and nuisance enforcement action, and two, whether or not the exclusionary rule would apply. So students, consider these issues as you're watching it. What could the implications of this case be in the future? I hope that you have lots and lots of questions. There's going to be a time to ask those questions and have them answered after the oral argument. So thank you all very much, and let's move forward with the arguments.
Good morning, everyone. Welcome to the 28th Court Community Connections Program. Before I call today's case, thank you to our hosts, to the students, and to the educators who have joined us today. We have students from Doyle Ryder, Fenton High School, Genesee Early College and Mott Middle College, International Academy of Flint, Lake Fenton High School, Powers Catholic High School, Southwestern Classical Academy, and Swartz Creek High School. My colleagues and I are very much appreciate the opportunity to be here in Flint with you and to highlight our commitment to community engagement, to accessible and open courts, to transparency, and to diversity. Thank you in particular to Flint Powers Catholic High School Principal Brian Sheeran and his team. Thank you as well to our co-hosts from the 7th Circuit Court and 67th District Court here in Genesee County, especially Chief Judge David Newblatt. And thank you to the local attorneys who have volunteered their time to brief local students regarding the case. The court is very much dependent on the local bench and bar for their support and cooperation. This event came together without as much lead as we would normally have, so we very much appreciate all the help to get ready for today. Finally, we are also grateful to the Michigan State Police, the Genesee County Sheriff's Department, and the Flint Police Department for their participation and assistance today. Welcome to everyone watching the live stream. And while you're online, make sure to follow the court on Twitter, Facebook, Instagram, and LinkedIn. A couple of housekeeping items. First, with the exception of the media and the professional photographers, no one should take photos once the oral arguments begin. There will be plenty of opportunities for photos during the reception. Second, if you have not already done so, please turn off all cell phones for the remainder of the proceedings. Following oral argument, please remain in the courtroom for the debriefing with counsel for the parties. Today, we have Michigan Supreme Court's Chief Commissioner Daniel Brubaker as our moderator. Oral argument is a key part of the appellate decision-making process because the issues raised and questions answered help determine the outcome and may affect the outcome of future cases that lower courts are bound to follow. By the time of oral argument, the justices are very familiar with the case. We've read the parties' briefs and the applicable lower court record, and we studied the legal issues. The questions we ask during oral argument and counsel's answers do help us reach a decision, but more importantly, they can help us, if we decide to render an opinion in the case, to craft an accurate and clear statement of the law. Like us, you have already studied this case. You know what the issues are. You've come to today's hearing with questions you would ask if you were a justice. And when the court issues its decision, you will get to analyze our ruling and decide whether you agree or would have done things differently. Our goal today is to leave everyone watching better informed about the rule of law and its role in our constitutional republic. My hope is that as citizens of your community, you'll remember this experience and maybe even be inspired to learn more about the law and potential careers in our justice system. Now it's my job to call the case, Long Lake Township versus Todd Maxson. This is a mini oral argument on the application. Both sides have 15 minutes to present their argument, and each have 2 minutes of a free fire zone, which you may waive if you choose, and you can reserve time for rebuttal, but we ask that you keep track of your own time.
Thank you, Chief Justice, and may it please the court. Oh, is it? Thank you, Chief Justice, and may it please the court. This case is about Long Lake Township's use of intrusive achieved with minimal, if any, social costs. This case presents this court a choice. It can keep the status quo, under which executive officials in this state have a blank check to use a drone to snoop around our private backyards whenever they want, for whatever reason they want, or it can hold that they may do so only when a neutral judicial officer agrees that there is good reason to do so. The court should take the latter approach, and it should apply the exclusionary rule to ensure that officials do not flout that rule. I'll start with the search question. I mentioned earlier the two tests that if the government violates either one, it has committed a search. I'm happy to answer questions on either test, but I'll start with the trespass test. The government has searched under the trespass test when it physically intrudes on a protected area in a way not licensed by the owner to gather evidence. No one here disputes that the drone was gathering evidence. In fact, the contract between the township and the drone operator is entitled, quote, "Proposal to Map Property for Code Enforcement." That's page 46 of our appendix. It was an unlicensed intrusion for Fourth Amendment purposes because the drone hovered at low altitude all around the Maxons' full property, including their home in curtilage.
Do we know what altitude the drone was flying at? Is that in the record in this case?
We don't know exactly the altitude, Your Honor. We know that the drone was under 400 feet as required by law because that is in the drone operator's affidavit. And as the Court of Appeals recognized, drones fly below what is typically considered publicly navigable airspace.
Is that just, is that the dispositive piece of this? We know that precedent is really clear that a helicopter can hover around backyards and do some surveillance. Obviously, the United States Supreme Court has said so. Why is this any different?
Your Honor, I recognize the Florida versus Riley case. Florida versus Riley was applying only the reasonable expectation of privacy test under Katz. It was not applying the physical intrusion test that the court reinvigorated in Jones. As this court recognized in Johnson versus Vanderkoy last year, there was confusion from around that time that people thought Katz had totally abrogated the physical intrusion test. Jones made clear that was not the case and that the test that was applied in Florida versus Riley is not the only test that parties may raise and that courts can apply. And here, under the physical intrusion test, this was a trespass, whether under the common law rule.
So is it your belief those helicopter cases, could those also be trespass cases then?
I think if the parties had raised and the court had considered the physical intrusion test that we now know from Jones applies, that Riley would have come out differently under the physical intrusion test, yes.
And how would that mesh with sort of our modern understanding of airspace? Understanding this trespass theory is sort of this, from the core of the earth all the way to the heavens. How does that work with modern airplanes?
So I think we can look to the Cosby case from the U.S. Supreme Court in the 1940s that holds that even under the circumstances of modern airplane travel, low altitude intrusions with airplanes is as much a physical invasion of a property owner's rights as is an intrusion on the ground. And courts around the country in Pennsylvania and Virginia and North Carolina and Kentucky and Colorado, all of which we document at pages 21 and 22 of our brief, are having no trouble applying those principles.
I think those states, like I know at least in Colorado, they have a specific statute that specifically defines aircraft, and I believe drones aren't part of that. Is that accurate?
I think that was right in the Colorado case, but Fourth Amendment case law, whether Jones or Jardines or Collins or this court's decision in Johnson, is not dependent on whether there is a particular statute from that state holding that this was a trespass. Instead, all those cases are looking to general principles of property law. Jardines is not pulling a Florida statute or a Florida case out of the books and saying, yes, this is when that became a trespass. It's general principles of property law that control, and I think we can look to Cosby for that, as well as the unanimous view of authority from around the country. For its part, the township hasn't cited a single case holding that drones may not be trespassers at the 400-foot altitude or below that they must fly at. This was also a search under the...
Just so we're clear, according to your argument, when is or at what altitude is a drone flight over someone's property a trespass?
So I think we can look to Cosby. Cosby seems to indicate that the demarcator between publicly navigable airspace and where private property rights begin is 500 feet because that's the altitude that airplanes cannot safely fly below. I think the same applies to drones as well. And our argument isn't that a drone over private property the moment that it crosses over the property line even an inch is necessarily a trespasser. I think we can look to Jardines, where the officers on the front porch in Jardines were not trespassers merely because they came an inch onto the front porch. As the court recognized, there is an implied license to approach the front porch by the front path, not quickly, wait to be received, and then absent invitation to linger longer, leave.
But just so I'm clear, so if it's a private drone operator not hired by the government, would it be a trespass if someone flew a drone over my house at less than 500 feet? Whether they were there to gather evidence or not, would it be a trespass?
I think the answer that I'm trying to get at is that there very well may be a customary implied license in the future for drones that are recreationally, quickly and incidentally passing through another property, not for the purpose of gathering evidence or gathering as much information about that property as they can, or maybe Amazon's commercial drone delivery service, quickly and incidentally passing through. Wherever that implied license may eventually draw the line, what the drone did here, which was prowl all around the Maxon's property for the purpose of gathering as much information about that property as possible, this is on the far end of the trespass side of that line.
Counsel, I'm curious, sort of extending upon what you were talking about private entities. We live in an interesting world now where something like Google Earth obviously can capture images of all of our backyards. I guess under either strand, is the reasonable expectation of privacy now diminished because of that? And also, is that a physical trespass?
So I don't believe Google Earth is a physical trespass because that comes from satellite imagery, and that's up in outer space. I think that's clear that that's not.
Even if it gets really good and can zero in and pretty high tech.
I think under Cosby's reasoning, I have to concede that in outer space, there's no physical trespass. Under the reasonable expectation of privacy test, however, if Google Earth is capable of doing what the drone did here, which is provide full property mapping on a moment's notice from any angle at any time that the township wants, and I think that is a search, but Google Earth doesn't allow for that right now. If the township could have gotten from Google Earth for free what it wanted, it would have just done that rather than pay 4 figures of taxpayer money to a drone operator to do so.
But I think it's interesting because this is what we're grappling with, right? Technology is rapidly changing. I don't think it's hard to predict that eventually Google Earth will have that capacity.
I think that's entirely possible. If that is publicly available in 20, 50, 100 years from now, then yes, there will be a diminished expectation of privacy if Google Earth is capable of that. But Google Earth is not capable of that right now. I'd concede there's no reasonable expectation of privacy from what Google Earth is currently capable of doing. The drone's capabilities far exceeded that, and that's why the township used the drone in the first place.
Since we're on to reasonable expectation of privacy, in addition to satellite imagery, the Supreme Court case law has said that fixed wing, photographs from fixed wing aircraft flying in the publicly navigable airspace or helicopters, those aren't Fourth Amendment violations. Don't those things, in conjunction with the satellite imagery that's available, taking pictures apparently to the same quality, same level of detail, don't those diminish your client's expectation of privacy?
So I'd push back, Your Honor, that either Serralo or Riley has blessed photograph surveillance from the air. Both those cases involved only naked eye surveillance. But Riley also,
What would be the difference between naked eye surveillance and a photograph?
So the difference is that what the township contracted here for was full property mapping of the Maxon's home. Riley and Serralo blessed only what the naked eye could glance down and mentally record as if they were a casual as if they were a casual observer simply passing through. What the drone is capable of is in hovering over the property for minutes at a time, taking photographs the entire time.
Let's do this hypothetical. What if the drone is flying at more than 500 feet and it uses readily available technology, camera technology, to take photographs? That, I think, according to your theory, wouldn't be a trespass, and it's in the publicly navigable airspace. Doesn't that, if you're allowed to do the drone, to fly the drone at that height and still capture those images, doesn't that reduce your client's expectation of privacy?
So 2 points in response, Your Honor. First is the drones may not be above 400 feet legally. The FAA standard is 400 feet or below. And secondly, Riley's plurality specifically says that the result would be different if the helicopter flights at issue there were contrary to law or regulation. And here, even under 400 feet, I think the drone flights and the drone surveillance here were contrary to Michigan statutes. MCL 750.539B prohibits trespassing on private property for the purpose of surveilling the owner's activities. And MCL 259.320 prohibits using a drone for something that would be prohibited if done by the person directly. So together, I think those statutes prohibit using the drone as an end run around what would otherwise need it to be a trespass to gather those photographs.
So the statute, though, doesn't say an activity. It says to capture photographs, video, audio recordings of an individual. And I think, how do you address your opposing counsel's argument that that statute isn't applicable? Maybe if it had, if the issue was having taken photographs or tracking an individual, like the Maxons themselves, as opposed to what physically exists on the outside of their property, visible to the naked eye from the air.
So 2 points in response, Your Honor. First, the statute that I'm referencing is MCL 750.539B, which prohibits trespassing for the purpose of surveillance, and 750.539A defines surveillance to include the owner's activities, not just the individual.
In order for that statute to apply under your theory, it needs to be a physical trespass. We would have to agree with you that it's a physical trespass.
Not necessarily, Your Honor, because read in conjunction with MCL 259.320, which prohibits using a drone for something that would be prohibited if done by the person directly. My argument is that the drone, in order to take those photographs without using the drone, it would have needed to trespass on the Maxon's backyard. So this is assuming even if the drone isn't a trespass, the township could have only gotten those photographs otherwise by trespassing. So those two statutes together would make this illegal under Michigan law if done by a private person.
Counsel, I just have a quick question. I always like to keep things relatively simple, and especially for our students here today, what would you say if this court was to not hold in your favor? What would you say the far-reaching, I'm going to give you an easy one, what would you say the far-reaching implications would be for ordinary citizens, homeowners, et cetera?
I think, as I mentioned in my introduction, the court has a choice. It can keep the status quo, and if that status quo is maintained, property owners can expect drones hovering around the low altitudes of their backyard for whatever reason any government official wants. If the court holds that this is a search, the government may only do so when trying to gather evidence if a neutral judicial officer agrees there's probable cause to do so.
Counsel, I know our time is running short, and I don't want to let you go without asking a likewise sort of a practicality question. If we were to agree with you that this is a Fourth Amendment search, then obviously a warrant is required. We have lots of district court judges here who well understand how warrants get issued. Normally, in criminal cases, that's how the police execute a search. What would be the process here to get a warrant? I haven't figured out how you get a warrant in a case like this.
I see that my time is up. If I may just
yes,
answer the
please.
question. The township could get a warrant the same way it would in any other case. It would have to build probable cause that there is evidence of some violation.
But do we have a process for civil warrants that we can go? I procedurally couldn't find any avenue that they would get a warrant.
Oh, it would be an application to a judge the same way that it would in any other case. The camera case from the Camera versus City and County of San Francisco from the U.S. Supreme Court holds that even for civil code inspection searches, a warrant supported by probable cause is required. And the township,
and I think in a lot of other states they have statutory pathways. I'm just wondering, does Michigan have a pathway to do this?
to obtain a warrant?
For a non-criminal, for a matter like this, like a zoning enforcement action?
Your Honor, I'm not sure of any Michigan statute. I'm happy to submit a supplemental brief if the court finds that to be a dispositive issue. But I think the process would be the same as with any other criminal case. The government would allege there is probable cause of some violation of the law, and they would build their case the same way they would for any other case. It would, interview neighbors and friends, or rely on substantiated tips, or use publicly available information, submit that to a judge, and if a judge agrees there's probable cause, as the Court of Appeals said, the township could get a warrant to fly the drone all around the Maxons property. We're here because it's half a decade later still insisting that it doesn't need that warrant.
Thank you.
Thank you, Your Honor.
Good morning, Madam Chief Justice, and may it please the court. Bill Henn on behalf of Long Lake Township. The simplest and most direct way to resolve this case is to affirm the Second Court of Appeals decision, which held that the exclusionary rule does not apply. This court doesn't even need to get to the merits of whether there was a Fourth Amendment violation, and the reason that is the most simple, direct resolution of the case is because there's only one case out there that applies the exclusionary rule outside of the criminal law context, and that is a case we've discussed. It's the 1958 Plymouth sedan case, and the reason that the exclusionary rule was applied there was because the civil forfeiture penalty was significantly more than the maximum penalty for the underlying crime. You don't have that situation here. This court should respect the fact that 1958 Plymouth sedan is the only example. Beyond that, if you get to the Fourth Amendment issue, the Supreme Court, United States Supreme Court, has held that visual observation is not a search. That's the Kylo case. However, even if this court applies the plain language approach that the defendants have advocated, which ascribes a meaning to search that's different than what the U.S. Supreme Court has, there wouldn't be a search here because you would still have to analyze the case under the Katz framework. The Katz framework is the only test that has ever been applied by the United States Supreme Court to an aerial observation. And under Katz, it's a two-part test. There's no violation under Katz because the defendants here did not exhibit a subjective expectation of privacy. There were no fences on their property. There was no roof or no awning over top of the items that were observed. Their property, their backyard, the back 5 acres, was not concealed from the neighbors. We have evidence that shows that all of this material that was accumulated was visible from adjacent properties. That's what started all of this in 2016 and 2017, was that there was a complaint that this was visible to other citizens in the township.
So, Counsel, I'd just like to ask a question. That's my thing. I like to keep it simple. But the question I'm going to ask is if you could refer back to Brother Counsel's response, and I'm just curious, what would the ramifications be, the large scope ramifications be if the court were to ultimately adhere? He's basically saying that drones would be flying everywhere, all across the land. And I guess my question is, for the students that are here today, is this something that the court should be concerned about? Is this something that would ultimately impact? Would there be any kind of protections for our citizens? And that's really what I'd like you to address is like, if we hold in your favor, is this going to amount to what Brother Counsel said, that it would be basically open season for drones on citizens across the country?
I don't believe that there's any concern for that sort of alarm. I mean, I think it's easy in modern day culture and with modern day media to envision terrible circumstances where drones could be used in ways that are incredibly invasive. And the township has never taken the position that a drone could not be used in a way that could implicate Fourth Amendment concerns. Our position is simply that when you look at the facts of this case, the way that this drone was utilized, it's no different than what you've seen in Cirolo, what you see in Riley, the aerial observation cases that the Supreme Court has addressed. I mean, this kind of gets to the heart of our argument, is that even if you go beyond the subjective analysis in Katz, when you get to the question of whether the expectation of privacy is reasonably objective, I don't think
that this court can get past the fact that we live in an age, and Justice Welch, your question was spot on, we live in an age where Google has mapped everyone's backyards. Not just that they could do it, they've done it already. And Google has a tool where you can even draw, if you want to know whether it's 50 feet from this house to this barn or 100 feet from this house to this barn, you do that right on the Google satellite imagery. And so given the reality of the world that we live in, how can there be a reasonable expectation of privacy in aerial observations of property? The pictures that the drones took here were absolutely indistinguishable from pictures that we downloaded from Google Earth. I would suspect if we didn't tell you which was which, you wouldn't know.
Well,
How do the,
How do the factors from Wolf play into our analysis? And do you think that they lead to the conclusion that the exclusionary rule should apply? I'm sure you're going to say no, but I'm struggling with looking at the Wolf factors, which tend to look at or tend to say that the exclusionary rule would apply. How do you analyze that?
I'm not aware of any case that would suggest that the exclusionary rule would apply here. There's a two-part test, right? The first is what if you apply the exclusionary rule, what is the likely deterrent effect on future police conduct, right? It's clear that the exclusionary rule is not intended to punish for past conduct. It is a judge-made rule that is entirely intended to prevent future police misconduct. We don't have police involved in this case, but even if you were to consider the township zoning official as a sort of policeman, I don't think that the deterrent effect is very strong here because this is a civil proceeding. This case has discovery. There's no Fifth Amendment guarantee against self-incrimination.
So is that where the inquiry ends? I mean, do we just draw a bright line between criminal and civil? I mean, that might be the easiest way to do it. Is that what you're proposing?
I believe that's what the courts across the country have generally done, is the exclusionary rule, and that's what Judge Gleicher found here, was that there's only one example anywhere that anybody can find where the exclusionary rule was applied outside of the criminal context, and it was that forfeiture case, and there were unique facts in that forfeiture case that aren't present here.
Aren't they always tied to some criminal activity in order to become a forfeiture?
Correct. There's an underlying criminal activity, and the court found it in the 1958 Plymouth Sedan case to be anomalous that the civil forfeiture penalty would be so much more significant than the criminal penalty.
It's intertwined. The criminal proceeding is intertwined with the civil forfeiture such
Correct.
that the exclusionary rule came into play.
Correct.
But what about the cases now with bodily fluids, like drawing blood?
Well, this court has addressed bodily fluid cases. Those are, you're asking whether the exclusionary rule would apply?
Yes.
I think
I
there's
mean, they pretty much, courts have said that they would apply there. How would you distinguish it? Because there's a huge difference between bodily fluids and a drone flying over property that's...
Well, I think that probably goes to the secondary component of the exclusionary rule analysis, which is balancing the societal interest versus excluding the evidence. And I think in those bodily fluid cases, courts have realized that that is such an invasive violation that it's almost beyond the pale. That there's sort of a visceral reaction to invading somebody's body that goes beyond taking a photograph from...
Even more so than invading the home.
Well, not invading the home.
No, I understand this isn't, but we have the home and then we have the backyard, and invading the body is even more intrusive than invading the home.
I think most people, if you had to create a hierarchy,
Yes.
I think they probably would say yes. They would rather have integrity in their body than in their home.
Was the trespass question fully developed and presented below into this court?
The theory of trespass is really interesting to me because, I mean, number one, I agree. The trespass test stands alongside the CATS test, but just because there's a trespass doesn't mean that you have a Fourth Amendment violation. I mean, what we're really talking about is what sort of trespass would give rise to Fourth Amendment concerns. It's not every trespass. I mean, this is the open fields doctrine, right?
My question is, was this fully developed?
Oh, I don't believe so. No, I don't believe in the trial court there was an issue about whether this was an actual physical trespass. I think that all came up on appeal.
And can we address the trespass without diving into air property rights. Don't we have to know what air property rights are first before determining whether this is a trespass?
I don't believe that you can address it without diving into air property rights. I also think that if you were going to conclude that that the Fourth Amendment standard in the state of Michigan is somehow equivalent to a common law trespass, you'd want somebody to bring a trespass action. You would want that record to be fully developed, and you would want to understand all of the nuances of trespass law. The Cosby case that counsel suggested, that's very different than what you have here, because those were large military jets, 4-engine military jets that were flying 18 feet above the tree line on this glide path. There were 150 chickens that were so disturbed by that they flew themselves into the walls of the barns and broke their neck. That is easy, I think, for a court to say, yeah, that's a true interference with somebody's possession or enjoyment of their property. That sounds a lot like a trespass, certainly like a nuisance. This case doesn't bear any of those hallmarks. This is a drone that, until the third time wasn't even observed by the plaintiff. And I'll slip in here. The first two observations in 2017, the defendants had consented. They had applied for a permit, and as a condition of the permit, they consented to township inspection of their property. So I think that goes to reasonable expectation of privacy. When you invite the government to actually put boots on ground in that instance, right? I mean, anyone from the township could have physically entered their property on the ground and made these observations. You can't say that they have a reasonable expectation of privacy.
Counsel, I just wanted to follow up on sort of the civil versus criminal distinction that Justice Clement was asking about. Would it have made a difference here if there'd been cumulative fines? If you had said, you get fined $250 a day for not fixing the salvage that you discovered from the drone, would that have made a difference in this case? In other words, does that turn it into something that looks more quasi-criminal?
I don't believe it makes it criminal. I think cases have said even where there are civil fines, that's not considered to be a criminal penalty. It changes, I suppose, the calculus that there would be a cost to the defendant, but it's not considered a criminal matter, even though there's a possibility for a monetary fine. Now, I'll point out that the township here never sought any sort of monetary sanction against the Maxons. It was always just about injunctive relief and to enforce the ordinance. Any other questions? Well, I see that my time's not up quite yet, but I feel like we've probably covered everything. I guess I would just say in closing, Your Honor, that I would implore the court, when it decides this case, to do so not based on subjective views about whether you like drones or you don't like drones. I mean, these are polarizing things out there. Some people love them. My son loves them. I know people that don't love them, and they think they're the worst thing ever, and they're afraid of them. But don't let subjective fears, and particularly subjective fears about what might happen, how a drone might be used, because I think we can all admit that there would be circumstances, in the right case where a court would have no trouble, even the U.S. Supreme Court would have no trouble saying, yes, this particular usage of this drone raises Fourth Amendment concerns. It's not this case.
Can I get you back to, I think it was actually your opening, where you urged or encouraged us to decide it on the exclusionary rule and not necessarily wade into the Fourth Amendment violation issue. Now, if we were to decide the Fourth Amendment issue and say that it wasn't a search, we wouldn't need to get to the exclusionary rule, correct?
If you decided there was no Fourth Amendment violation,
so
then correct.
What authority would suggest that we can sort of assume a violation and just decide decided on the exclusionary rule? What would be the reasoning, or are there cases where that has been supported?
I don't know specifically in the exclusionary rule context, but I do know that courts, I think this court and pretty much any appellate court, when they're faced with a case that has multiple issues, if a decision on one of those issues renders the other ones moot, a court always has the discretion to say, well, because of our conclusion on this issue, we really don't need to address these other issues because it doesn't matter.
Sort of like analogizing, like in the qualified immunity context, right? That you can decide the clearly established prong without deciding whether or not
Right.
that there's a violation. But the Supreme Court has officially sanctioned that sort of process, right? That you can decide the second issue without the first. Is there authority that suggests that we could just decide it on the second issue as opposed to actually having to decide the Fourth Amendment violation?
I mean,
And
again,
can I just follow up on that? Because I think that one of the things that I'm struggling with is when you said just decided on the exclusionary rule, there has to be an assumption made on the Fourth Amendment question.
well, I
Can't
think,
I mean, we have to assume that there's not a violation.
I think what the court would say is that regardless of what our decision would be on the Fourth Amendment violation, our decision on the exclusionary rule would be that it doesn't apply because it's never applied anywhere in the country in this sort of circumstance. And so we're going to wait, until we have a case where the exclusionary rule issue is relevant before we dive into or before we start to untangle the Fourth Amendment knot. Your Honor, I guess, the last thing I'll say, my time's up, so I think I've said my last thing.
You can finish your thought.
With reference to the decision-making process, understand that the legislature has taken a look at this. They have taken the first pass at deciding, at balancing the public's right to use drones versus the individual's right to privacy from them. And as Justice Kavanaugh pointed out, the only thing that's prohibited is an observation of an individual engaged in an activity that would otherwise carry with it a reasonable expectation of privacy. I think, and I would implore the court to be deferential to the legislature's attempt to start to define these parameters. Thank you, Your Honor. It's been an honor.
Thank you very much. And we have used all of your time, but for the sake of the students, how about 30 seconds of rebuttal so they can see what that looks like? Huh? Do you have a question?
I appreciate that honor, I appreciate that in 2 points. One, a drone going to your property is not going to know whether it's going to see a person or whatever activities it's going to see, and that's why people have a reasonable expectation of privacy from drone surveillance on their property. The drone could see anything, and people don't know what that will be when the drone is deployed. And second, Your Honor, you were spot on in citing to Wolf. The issue in all of the civil cases on the exclusionary rule is whether the deterrence benefits would outweigh the costs, not whether the label is civil or criminal. And I didn't hear anything from the township explaining why the deterrent benefits would not outweigh the costs. Thank you.
I just have one question. And can you respond to opposing counsel's point that you essentially don't have a reasonable expectation of privacy when you make permit applications and consent to inspection of the property?
I can, Your Honor. Black letter law on consent is that it must be specific and unequivocal, and the government cannot exceed the scope of valid consent. Even if my clients consented to an inspection of a perimeter fence around their property, that does not mean that they acceded to the scope of drone surveillance looking for code violations all around the interior of that property.
Okay.
All right, thank you,
Thank you, Your Honor.
all. And the case will be submitted, and the court is adjourned.
we have trial counsel here too. Could I invite him as well? Yeah, let me ask him.
You like Okay.
Is it weirdly going to like one in one? Unless you want two, that's fine. Do you have are there people with microphones that are going to?
Just right around the left. Yeah, hard left.
Okay, good morning, everyone. We are going to start the next stage of our program, which is the heart of the program, of the Court Community Connections program, which is what we refer to as the student debriefing. And I want to start by saying that arguing before any court can be a little bit nerve-wracking. Arguing in front of the Michigan Supreme Court can be particularly stressful. But agreeing to argue in front of the Michigan Supreme Court with a bunch of judges and students at your back is kind of above and beyond the call of duty. So if I could get a round of applause for our attorneys here today, please. And I also wanted to kind of reiterate what the Chief Justice said on behalf of the Michigan Supreme Court. Thank you to Principal Brian Sheeran and the whole community of educators and administrators here at Powers Catholic High School. And of course, a big thank you to 7th Circuit Court Chief Judge David Newblatt and to the justices and to all the other judges who took their time to be with us today. I want to say, the cool thing about my job is that I usually get to be with the justices when they are in conference discussing the cases that they have just heard. And it's really fun, and that's what's going on now. If you're wondering what they're doing, well, you are in here. The justices are sitting around at a table, all talking to each other. And everything is open at this point. There are many things they could do. One option would be to deny leave, which would mean to say we're not going to do anything more with the case, in which case the Court of Appeals opinion would stand. They could say we're going to do an opinion, and that opinion might say we're going to reverse the Court of Appeals. We're going to reach a different result, and here's why we are reaching a different result than the Court of Appeals. Or they could do a long opinion that affirms the Court of Appeals and says the Court of Appeals reached the right result, and here's why we think that. And if there is an opinion, a justice could do a statement that what we call concurring, which is a statement from a justice saying, I agree with what the court is doing, but I want to say a little bit more. Here's what I think. Or a justice or justices could do a dissenting statement and say, we disagree with what the ultimate result of what the court is doing, and here's why we would have come to a different conclusion. The court could even theoretically ask for more briefing on the case and say, some interesting things came up. We'd like the parties to submit additional briefs because we want to explore another issue. So there's a whole wide range of things the court could do. I have no idea what they're going to do, but I do know this. When the justices are back there talking about the case, they're going to be talking about what they've read in the briefs. They're going to be talking about the law. They're going to be talking about the facts of this case, how the law applies to the facts of this case. They're going to be talking about what they heard here at oral argument today. It will be discussion. If they all agree, that's great. If they don't agree, the people on side A are going to try and persuade the justices on side B why they're right, and the justices on side B will try and persuade the justices on side A why they're right. It will be discussion. It will be attempts at persuasion. It will be deliberation. And then ultimately they will vote, and they will reach their decision. And I, for one, think it's a beautiful thing to see conflicts being decided by discussion, deliberation, and voting. So we're going to have about 25 minutes or so for questions before we head to the reception. I have some questions if the room goes silent, but frankly, I'm hoping I don't have to ask those questions. We do this for you. We are all very interested in knowing what you thought about what you just saw up here and your reactions to it and what you think about it and any questions you have about it. So please don't be shy. If you have a question, we want you to ask it. So I think there are some microphones that will be passed around. So if you have a question, please raise your I think this is how it's going to work. If you have a question, raise your hand and someone will pass a microphone to you. And before we do that, I just want to kick things off with this. And when we are in the court, the appellant goes first. So I'll start with the attorney for the Maxons. If you would just please introduce yourself and just say a little bit about your practice as an attorney.
Sure. My name is Mike Greenberg. I'm an attorney with a firm called the Institute for Justice, and we are a national nonprofit law firm, in fact, and we litigate all over the country, not just in Michigan, but everywhere. And our specific mission is to defend constitutional rights against government encroachment, and that's what made this case so interesting to me and my colleagues.
And the attorney for the township.
Well, good morning. My name is Bill Henn. I am the attorney for Long Lake Township on appeal. The gentleman to my right represented the township at the trial court level, so I thought he might have some interesting things to say, depending on what the question is, but I'll let him introduce himself separately.
Hi, my name is Todd Millar, and as Mr. Henn indicated, I was the trial court lawyer way back in 2018 when this originally got started.
And with that, we will begin with the questions. I see hands over here. Oh, there you
Hello. So there was a lot of talk about reasonable expectations of privacy, and my question is, what would be the minimum that a drone wouldn't be able to survey them? Would you need like a chain link fence or a solid privacy fence, or maybe covering all of the yard with some sort of tarp? What is the minimum you could do to not be surveyed is the question.
Well, I can take a shot at that. I mean, my view on it would be there is no bright line test for whether you have exhibited a subjective expectation of privacy. I think a court would look at any case and look at the facts specific to that case and decide whether on those facts there was evidence that the individual had expected that their activities or their property was going to be private. And the different sorts of fences that you mentioned would probably weigh into the court's determination. I think a chain link fence would probably give less of an inference of an expectation of privacy than a 10-foot tall wooden fence.
And I'm going to respectfully disagree with that, because when it comes to a drone or from surveillance from the air, a fence doesn't really make a difference one way or the other, and I don't think people should need to completely, tarp off their backyard, with a horizontal fence or a tarp or something like that to maintain their expectation of privacy, at least against aerial surveillance.
The man representing the township mentioned that they consented to 2 ground inspections beforehand, and that the images were also clearly available from Google Maps, and that it was also visible from a neighbor's property, and that there was no fencing or roofing. If that was all the case, then why was there a need to spend thousands of taxpayer dollars to hire a private company to survey their property with drones?
Yeah, I had a hard time understanding the question. I think it sounded like, if there weren't fences and things like that on the perimeter of the property, then why was drone surveillance needed in the case? Was that the gist of it?
Yeah.
Yeah, I mean, I think that drone surveillance is a tool, right? Drones are a tool that government can use, that private individuals can use, and cases have said that, the government does not need to avoid using any particular sort of technology that is available in the general public to go about its legitimate business. And so, I mean, in this case, I know the township did have photographs taken from adjacent properties that showed, you know, various angles of the Maxon's property that could be observed from different vantage points. But just because they have that doesn't mean that they shouldn't also attempt to strengthen their case, you know, by any lawful means.
Yeah. So to kind of get to the heart of the question that you asked, there was an issue that came up. As you remember from the slideshow, there was a 2007 lawsuit that got settled in 2008. One of the concerns that the judge had in that case was some language in the zoning ordinance that talked about if the materials were moved every 30 days, then it wouldn't be a violation of the township zoning ordinance. And that's one of the reasons why the township hired a drone operator in this case to take 3 sets of photos of this property and if you look at the dates of those sets of photos, some of them are roughly 30 to 35 days apart. And that's because the township was taking a look at determining whether or not any of the items on the property were being rotated and moved around on that 30-day interval. And so that's why the township, one of the reasons why the township decided to use a drone instead of just surveillance from neighboring property, because you could easier see if materials or different vehicles, different piles of stuff were being moved on a rotating basis. I'm sorry, I can't hear you. They were denied access to the property. And there wasn't a lawsuit going on which would have given the township the ability to demand a site inspection. And so if a property owner says, stay off my property, the township doesn't have the ability to go on there physically, boots on the ground, to inspect it.
There was an open thing where a little snippet of the defendant, in this case, the township, said that they openly trespassed on the property.
I'm sorry, we're having a lot of trouble hearing up here. If you wouldn't mind speaking very
Okay.
loudly, we'd appreciate it.
There was a little part of the defendant's case where they said they did openly trespass on the property. They openly said that they did. Is there any way that, I mean, with a drone, I guess, yes, you can trespass, but what constitutes between the Fourth Amendment where they're actually gathering evidence with their trespass, or is there what's the line there? That's the question.
Could you hear?
It sounded like the question was where the Fourth Amendment gets implicated and how do you know that they're gathering evidence. The Fourth Amendment, that trespass test, it applies when there's a trespass and when the purpose of the trespass is to gather evidence. The gist of the dispute here, I think, is not whether the drone was gathering evidence about the Maxon's property. I think everybody concedes it was trying to find violations of the zoning ordinance. What the back and forth with us and the justices was about is whether the drone could be a trespasser at all. We think the answer is yes, because you maintain the right to exclude unwanted flying objects on your property. And of course, our friends on the other side don't agree with that.
Yeah, I mean, I would say that's a fairly accurate answer. I mean, that's what courts are doing in all of these cases that we've studied and that we've briefed to the Supreme Court and that we talked about here today, is they're trying to find that line whether what the government did implicated some sort of constitutional concern, rose to the level that it actually became a matter of constitutional concern. And that's why you have courts promulgating different sorts of tests depending on certain circumstances in each case. And so, I mean, it really is sort of a free flow process where, the law might look one way at one time, and then there could be a whole nother case that brings a new perspective to it, and it's a constantly evolving scenario.
I noticed that you guys mentioned something about Google Maps and how it was like in space taking pictures, but there's always like a bus that also takes pictures, which would be like closer than 400 feet, and it could take a pretty good picture of the front of your house, maybe the side. So how would that do with trespassing?
I'm really sorry, but I heard the first part of the question and then it trailed off.
Oh, I'm sorry. Okay.
I hate to ask you to repeat it, but.
Okay, so you guys were talking about Google Maps and how they take aerial pictures from space, but there's usually a bus that takes pictures down the street that would be closer than 400 feet.
Yeah, there's aerial photos on Google and there's photos from the street. And one of the things that we argue is that the Maxons had a reasonable expectation of privacy in their backyard, because if you go on the Google Street View, you can't see into the backyard, the way the house is laid out, the way the driveway kind of slopes upward, the way that there's a garage blocking the view. And so that's why the drone had to do what it did in the first place, was because the backyard isn't visible from the street. It is, of course, visible from Google Maps or Google Earth, but I think I had a back and forth with one of the justices explaining that the drone and Google Maps or Google Earth are different because Google Maps and Google Earth update, on set schedules by Google, and the government doesn't get to say or see exactly when the view is or what the angle is. The drone does provide them that. It can go to whatever angle it wants. It can come back whenever it wants, unless, of course, the court holds that it's a Fourth Amendment violation.
I had a question, just like, so there was talks about like why they were there or what they were going to see. Why isn't it just more of a question of if there was if the drone was in the property lines of the house, like just what's the like aerial limit, I guess you could say, like if they were inside of that area, why is it more outside of just, do you get what I'm saying? Like.
Yeah, it's because there are two separate tests for whether there's a Fourth Amendment violation. There's that first test that we talked about for a while, which is the trespass test, and there's the second test, which is the reasonable expectation of privacy test. If the government violates either one of those tests, it's committed a search. And so I think when you're a lawyer advocating on behalf of a client, you want to make not just what you perceive to be the best possible argument for your client, but every argument that you think is winning. And from our perspective, we think this was a search under either of those tests. But whether the drone was trespassing or not doesn't matter for the privacy test. It only matters for that first test, which is the trespass test.
Right. So I guess my question is, what's the like aerial limit of your specific like private property, like feet wise?
So from our perspective, we read the cases to say that 500 feet is the altitude at which separates the publicly navigable airspace from where your private property rights begin. And the law on drones is that they necessarily, under federal law, can't safely fly above 400 feet. And so our argument is that the drone, no matter what the exact altitude was, because everyone agrees it was under 400 feet, it was a trespasser on the Maxon's property.
And I would just add, obviously we disagree about the application of that 500-foot standard. That's one of the things that that we've disagreed about and that we've briefed, and that the court may eventually decide. But there are cases that the United States Supreme Court has decided where helicopters have flown as low as 100 feet above a property, and the court has determined that that did not rise to the level that would give any sort of Fourth Amendment concern. And so, I think the best answer to your question is that there isn't a bright line, altitude at which you have a property interest that can't be invaded. It's just the courts aren't in agreement on that.
So if The public airspace is, you said, defined as 500 feet. What would separate, like how you get a warrant for, if you flew a drone in public airspace, would that, and took pictures of a property, would that constitute,
I'm sorry, I didn't catch the very end of that question.
would flying a drone, if it was in public airspace, would that require a warrant, or would you need to get, like if you were taking pictures of someone's property, would you need like permission from a judge to?
Well, the township's position is that that would not require a warrant, that if the drone is in publicly navigable airspace and it's in an area where it is legal to operate that drone, and as long as it's not operated in a manner that becomes overly invasive, because courts have looked to that at times to say, well, look, even if what you're doing is arguably legal, if it's harassment or if it's overly invasive or intrusive, then that can factor into the court's analysis as well. But in the absence of that, our position is if you're in a spot above the ground in an area where the drone can lawfully operate, then you don't need a warrant for that.
Well,
Yeah.
what if it's not public airspace? Like, what if you're flying the drone below public airspace, like in the person's property? So would that need a warrant?
I had a hard time understanding the question. Was it that if the drone was at an altitude that was very low?
Yes, like as.
And
is
I mean,
in this
I think the township would concede, and we mentioned this to the justices, that there are conditions under which a court could conclude that a drone operation raises Fourth Amendment concerns. And you can come up with all sorts of hypotheticals, but I think one that the Court of Appeals used here in the original case, in the first case, is a fairly common example. If somebody flies a drone outside of your kitchen window or outside of your bathroom window and peers into your house, I think, even though that may not technically be a trespass because they're not touching any part of your property, it's certainly very intrusive. And I think that courts in that circumstance would not find that activity, they would not look favorably on that sort of activity.
So
I think that would even violate state law at this point.
So what would separate looking in through a kitchen window from looking at someone's backyard? Like, wouldn't it all be your property, and it shouldn't?
I'm sorry, the question was what separates looking into someone's kitchen window versus other aspects of the property?
Yeah, it's all your property, so you should have a right to privacy on your property.
Sure. Well, in terms of Fourth Amendment case law, the home is given, I think the phrase that the United States Supreme Court has used is that it's first among equals, which means you have the highest expectation of privacy in the interior of your home. That's where most of the intimate family type activities take place, and so courts are particularly protective of the interior of the home. As you get further away from the interior of the home, the actual physical building of the home, there's an area that's described as curtilage, and curtilage is an area that's not in the home but is relatively close to the home. That gets some protection, but not quite as much protection as the inside of the house gets. And then beyond the curtilage are what the courts have called open fields. And open fields, even though it's your property, don't give rise to any sort of Fourth Amendment concern.
This is the question for both of the attorneys. This isn't exactly about the case. The justices asked you guys a lot about specific questions or instances where you had to come up on the spot about examples or ways to justify your case. How were you able to prepare for that? Because I've watched a lot of court cases, and oftentimes I can't seem to come up with the amount of questions the justices will or will be able to prepare for them. How are you able to do that?
Could you, I had a really hard
Not
time.
hearing it?
It sounded like the question is how do you prepare for knowing what the justices' questions are going to be? Is that?
Yes.
With painstakingly. Certainly at the firm that I work at, we do what's called moot courts a lot, which is kind of simulating what the argument is going to look like, where people read the briefs, they study on the cases with you. and practice doing the argument, trying to anticipate what kind of questions the justices might answer. And I think that's what any good and skilled advocate does is practice makes perfect, right? And not just in the law. There could be a question that comes up that you haven't practiced, but the goal is to have kind of simulated what this kind of thing will look like, such that you're not surprised by anything that any of the justices asked. And having friends or colleagues who are able to sacrifice and help you along with that is something that I think is really valuable for any lawyer.
I think that's right. I think you read, I think you think things through, I think you talk to as many people as you can, get their opinion, try to, don't just rely on your own view of the case, but try to solicit as many different viewpoints as you can, and then equally importantly, give up on the need for sleep.
Thank you.
My question is for the attorney defending the township. So you brought up in your argument that the Masons were not aware that the drone was flying over their property until the third time that it occurred. Couldn't that also be a violation of their Fourth Amendment rights, that the township was flying a drone over their property without their prior knowledge?
Boy, I picked out some of the words. I'm sorry. I'm having a really hard time hearing.
I'm sorry. So you brought up in your argument that that the Maxons were not aware that the drone was flying over their property until the third time that it had occurred. Couldn't that also be a violation of their Fourth Amendment rights, that the township was flying a drone over their property without their prior knowledge?
I guess your question is going to consent, and we had mentioned that with the first two flyovers, they had applied for a permit that allowed the township to inspect the property even on the ground. With respect to that third flyover, the permit had expired, but our position is that under the law, that flyover, because of the way that the drone was operated and because of where it was positioned, that those observations from the sky did not violate any reasonable expectation of privacy of the Maxons, and that prior permission from them is not required under the law.
And you saw me push back on that with Justice Zara, that even if there was consent to inspect a fence around the property, which is what the permit was for, consent to look at a fence on the outside of the property is very different from agreeing to have a drone fly all around your property looking for what I think we'd all agree is unrelated code violations. And so that's what that disagreement is about as well.
Was the permit specifically for searching the outside area by the fence, or what was it for?
The permit was specifically for a fence around the property, yes.
Okay.
I have a question from a friend. So why pay a private company to use a drone rather than just get a warrant? Is it that you couldn't get a warrant? Everybody's laughing.
Again, it sounded like the question was about a warrant.
Yeah.
Yeah. Well, when you look at a Fourth Amendment question, the question that courts ask is never how easy would it be to get a warrant, or why don't you just go get a warrant. The question is, what does the Constitution actually require? Does it require you to get a warrant under these circumstances? And that's essentially what this case is all about. The township believed at the time that a warrant was not required, and we still believe that a warrant was not required, but that's one of the issues that I think is central to the case.
Also, so why did you pay a private drone company instead of trying that first?
Why did they
pay a private drone company instead of trying to get a warrant first?
Why did they pay the drone company instead of getting a warrant first?
Yes.
Well, I think, the answer is the same, which is that they didn't believe, and they still don't believe, that a warrant is required for that sort of activity.
Thank you.
So I had a question about, you said in your argument that the drone was doing observations, but didn't it take photographs, and isn't that completely different than an observation?
I'm sorry, that the drone was,
Taking, you said it was taking observations and not
oh, are
photographs.
photographs different than observation? Is that the question? I don't believe so, no. I think that the Supreme Court, if you look at the U.S. Supreme Court cases, some of those cases involve just what they call naked eye observation, where you're just looking out the window of an airplane or looking out the window of a helicopter. Some of them involve taking photographs, and the court has said when you use a device that's available in society to enhance your naked eye observations, as long as it's generally a publicly available device, it's not like infrared technology or something like that, it's fine to do that, and it's the same as, you know, a naked eye observation.
Thank you.
So I think a big problem for me with this case is the idea of knowledge and consent. And I think it's important to note that when the Constitution was written, there was no such thing as technology or drones. The people that wrote the Constitution had no way to know that that would be a thing. And now that people don't have that protection, and there was nothing written there because people had no idea that that could possibly exist, I think that's where the major issue for me of privacy is coming. So what do you have for the township? Do you have a response to that? Why do you think that a person shouldn't know? Because if you had a 10-foot fence, there would be no way to see the property without a camera, which wasn't a thing at the time that the Constitution was written, so there's no protections in place for that.
I really had a hard time. It sounded like you were saying without the camera, the township wouldn't have been able to observe the property. Was that the gist of it?
Yeah, so when the Constitution was written, they had no way to know that cameras and the technology that we have now would exist. So, of course, there's no protection for citizens. And I think that's an important thing to note, that now as technology is progressing, that people don't have those protections that they should have before.
I mean, I can try to answer the question that I thought that I heard, but I still am having a real hard time because of the acoustics. But I think generally the U.S. Supreme Court has said that there really isn't any difference between what they've called a naked eye observation and an observation with something like a camera, a 35 millimeter camera, something like that.
It sounded to me like the question was about what people might have thought at the time the Constitution was ratified. And we certainly didn't have cameras at the time the Constitution was ratified, but I think if we just put ourselves in the framers of the Constitution's shoes, we can think about what they might have thought about people, kind of hovering over their property. And I think just in their shoes, it would make a lot of sense that that is something that they would view as a violation of their privacy or of their property rights. And sure, we didn't have helicopters or airplanes back then, but hot air balloons existed. And I think if we put ourselves in the shoes of one of the framers and there's kind of a hot air balloon floating about their property, I think they'd feel violated, just like I think the Maxons feel violated by the drone today.
And I absolutely agree with the defense, and I think a good note is that we were talking about Google and Google Maps, but the thing about Google Maps is that you cannot go to Google Maps and get a readily available picture of any area at current times. Several of the pictures, or in most places, they will be several years old. And most locations, you cannot just, if I went to my house right now, the picture that I would see of my backyard is from probably 4 years ago.
I think that's one of our arguments as to why Google Maps or Google Earth is so different from the drone, is that the drone allows the township not only to get whatever angle it wants, but if the court doesn't hold it to be a search, to come back any day that it wants, not at Google's whims whenever it updates those satellite images.
Yeah, and like I said, I agree with you. So for them, I was asking, why do you feel justified in that, since you don't have that readily available picture? if the Maxons had a 10-foot tall fence, they would have had to consent to the search and had knowledge of it.
I didn't hear.
Okay. I hate to say it, but our time is up. So I apologize if you had questions that you wanted to ask. One thing that I should have told you about the justices' decision-making process is that even though they have now voted, and so they preliminarily know what's going to happen, no one outside the court knows what's going to happen until they issue an order or a decision. And I say that because at the reception, you're going to, if you have any questions, and just to say hi, please go talk to the justices, but don't ask them what they decided today, because I can't tell you that. So what we're going to do now is first we're going to have the judges leave, so they can leave out the aisle, and then with security will escort you. And then after that, we are going to dismiss the students by school. So I'll leave it to the student advisors to do that. So again, please feel free to speak with the justices or the attorneys or anyone at the reception, and we will see you there. Thank you.
Thank you very much.
Oh, thank you. I appreciate you guys doing this.
Thank you very much. Take care.
Nice
Yeah.
job.